Thanks very much for having me. It's a real honor to raise the microphone. It's a real honor to be invited to speak in front of the New York Historical Society, especially for me. I'm really more of a law professor than I am an historian, and I'm also a Boston Red Sox fan and have really hated the Yankees for most of my life. Thank you. I'm going to the game tomorrow, but I'm too much of a coward to wear my Red Sox cap. I've written a really long book. I showed it to my friends, and their reaction was, it's so long. I always hoped that they would say something like, it's beautiful, or it's great, or even that it's really well illustrated, which, by the way, I think it is. But their reaction was always, it's so long. Unfortunately, because it is so long, I'm not going to be able to summarize it except very briefly. And what I'm going to do tonight is I'm going to talk about 4 points that are raised in the book, and all of them bear on Brown versus Board of Education, which is arguably the most important decision in the Supreme Court's history, and still today shapes our understanding of the Supreme Court, shapes our understanding of law and social reform. So I want to make 4 points about Brown. I'm going to try to do this in 35 or at most 40 minutes and leave time for questions. Point number 1, Brown was in fact a hard case for the justices. Point number 2 is to explain why it was a hard case. In essence, I'm going to argue it was a hard case because it posed a conflict for the justices between their legal interpretation and their own personal moral views. Third, I'm going to try to explain why they were able to reach the outcome that they did, notwithstanding their legal doubts about the reasoning behind the decision. Again, in a nutshell, I think the explanation is that there were dramatic changes in racial attitudes and practices sweeping the country as a result of World War II, and the justices were as influenced by those as the rest of society. And then fourth, and at greatest length, I'm going to talk about Brown and the civil rights movement, try to say some things about the connections, the consequences Brown had for the civil rights movement of the 1960s. So first, and most briefly, Brown was a hard case for the justices. I think it's hard for us to appreciate today that that could be so. The decision is unanimous, and of course unanimity connotes ease of decision, not difficulty. In addition, I think it's hard for us today to imagine anything that seems more obviously unconstitutional than state-mandated racial segregation in schools. Nonetheless, when the case was first argued in the fall of 1952, the justices were deeply divided. Bill Douglas dictated a memo to the files the day Brown was handed down, May 17, 1954, in which he reported that if a vote had been taken after the initial argument, the case was argued twice, once in the fall of 52, once in the fall of 53, but Douglas reported that if a vote had been taken after the initial argument, that the vote would have been, quote, 5-4 in favor of the constitutionality of segregation in the public schools. That is, they would have reaffirmed Plessy, they would have upheld segregation by 5-4. Felix Frankfurter reported a slightly different head count. He thought that a vote would have been 5-4 to invalidate segregation, but there would have been 4 justices writing dissenting opinions. The conference notes from the case which survive confirm that there was in fact deep division. Why was the case so hard? Turning to the second point. Well, as I've already alluded to, I think the reason is because the justices were conflicted between their personal values and their legal interpretations. Most of the justices thought that racial segregation was an unambiguous moral evil. Justice Black referred to it as Hitler's creed, and most of the justices agreed with that. Not all of them. Stanley Reed, for example, from Kentucky, we know, thought segregation was not only constitutional, but it was also defensible as a matter of social policy. But for most of the justices, and here I'm going to focus on Frankfurter and Jackson, for whom the case was hardest, for most of the justices, racial segregation was an unambiguous evil. The difficulty was they weren't sure that it was unconstitutional. In a 1950 letter, Robert Jackson, who had left the court, as you may know, for a year to prosecute Nazis at Nuremberg, he wrote to a law professor friend, quote, "You and I have seen the terrible consequences of racial hatred in Germany. We can have no sympathy with racial conceits which underlie segregation policies." I think that's representative of what most of the justices thought about segregation. Frankfurter's another good example. He had been an advisor to the NAACP in the 1930s. He'd hired the court's first African-American law clerk, William Coleman, in 1948. Nobody who knew Frankfurter had any doubts that he saw racial segregation as an obvious moral evil. But the problem was that Frankfurter and Jackson were both deeply committed to the idea that judges had to separate their own personal views from the law. In a memo that he wrote while the Brown case was pending, Frankfurter insisted that his personal views on segregation were of limited relevance, if any relevance at all. Quote, "However passionately any of us may hold egalitarian views, however fiercely any of us may believe that such a policy of segregation is both unjust and short-sighted, he travels outside his judicial authority if for this private reason alone he declares unconstitutional the policy of segregation." The court could only invalidate segregation, Jackson and Frankfurter believed, if it was legally as well as morally objectionable. But the difficulty was they had trouble coming up with a legal argument against segregation that convinced them. Frankfurter had his law clerk, Alexander Bickel, who later became a famous constitutional law professor at Yale. He had him spend an entire summer reading the legislative history of the 14th Amendment, and Bickel reported back to Frankfurter, who then circulated this memo to his colleagues. He reported back that it was, quote unquote, impossible to conclude that the authors of the 14th Amendment had either intended or foreseen that the amendment would abolish school segregation. Now, it's true Frankfurter was not a doctrinaire originalist. He believed that the meaning of constitutional concepts can change over time, but he didn't think that meant that judges were free to simply write their own personal views into the Constitution. In the early 1950s, there were 21 states plus the District of Columbia that still had segregation written into the law. That made it very difficult for Frankfurter to conclude that evolving social standards condemn the practice. Precedent strongly supported the practice of segregation. Between 1865 and 1935, there had been no fewer than 44 cases decided by the highest courts of the states and lower federal courts, and those 44 decisions were unanimous. Every one of them rejected the constitutional challenge to school segregation. Frankfurter ordinarily celebrated what lawyers call the rule of stare decisis, which simply means the rule of precedent, that courts should respect decisions that have already addressed the question before the court. He called stare decisis, quote, the most influential factor in giving a society coherence and continuity. At the Justices' Conference, Frankfurter concluded, based on the legislative history and based on precedent, that, quote, Plessy is right. Plessy, of course, was the 1896 decision upholding the constitutionality of state-mandated segregation on the railroad cars. Now, Robert Jackson thought about Brown in a very similar fashion. He revealed his internal struggles in a draft opinion he wrote but never published, which is one of the most fascinating documents I've ever found in the Justices' papers. This is a draft concurring opinion. We don't know whether he was planning on filing it or not. He ultimately suppressed it, but it is extremely revealing of his own personal thoughts about Brown. This is how he began that draft concurring opinion. Quote, decision of these cases would be simple if our personal opinion that school segregation is morally, economically, or politically indefensible made it legally so. But Jackson thought that judges were obliged to subordinate their personal views to their legal principles. When he turned to the question of whether existing law condemned segregation, he had difficulty answering in the affirmative. Quote, layman as well as lawyer must query how it is that the Constitution this morning forbids what for 3/4 of a century it has tolerated or approved. He, meaning layman or lawyer, must further speculate as to how to justify this reversal of its meaning by the branch of the government supposed not to make new law, but only to declare existence.